My topic is intellectual property protection, innovation and monetization. I think we've amply covered the protection and innovation here, but I would just briefly touch on those points. So the first question that everybody is faced with is, you have a brand or an innovation. Is it worth protecting? Protect pannalama venava, idukku kaasu selavu pannalama venava. Do you really go for a patent, or do you go for a trademark, or do you just, sit with it? That's a first question that every entrepreneur is faced with. Then you need to ask yourself, do you want to reap all the benefits out of your brand or your invention? Do you want to, solely reap all the benefits out of it, as the case should be? Or do you want to share it with somebody else? So let me just explain that. You have a brand, you develop it. For example, you have a brand called ABC for, refined oil. You develop it. Tomorrow you see that there is somebody else coming with a CBC, the C written in a stylized manner that people would, mistake it for your brand. At that point of time, you do not have a registered trademark in hand. You do not want to file a registered trademark because the other person is so small that he's negligible. And you think, okay, I am doing business, I am earning profits, I'll go ahead with my brand, what is there? I mean, after all, he is only CBC, not ABC. You go ahead with your brand and you also make profits. But in the long run, you see that, the profits that you are now making are not what you were doing. And then you understand that CBC has slowly built up and is actually eating into your profits. So then you understand that you are not reaping all the benefits out of your brand or your innovation. You're actually sharing it with somebody else. Is this what you want? Do you want to have it all, or do you want to, share it with somebody else? That's the first question that you have to ask to yourself. And I'm sure that the fact that you want to solely reap all the benefits out of your invention or your brand, the answer would be a resounding yes, yes, and yes again. That's where we come to IP protection. You need to protect your IP through the filing of your trademarks, filing of a patent for your innovation. Only that would ensure that you get to have all the benefits out of what you have created. IPR are more than one tool. I mean, all of us know about patents, trademarks, copyrights, designs, geographical indications, plant variety protection. So it is not just one thing. One product is capable of so many protections. So you need to go for a fortification, like a fortress all around your product or your innovation or your brand, to make sure that it is amply protected and nobody can, attack from any crack that is there in the fortress wall. IPRs give you control. You can decide what to do with your innovation or creation. If your invention is not being completely utilized as you had envisaged it would be by your company, sell it for a good price if you see that somebody else needs that invention. So having a patent in hand gives you the freedom to decide what you want to do with that particular invention, with that innovation. And IPRs are country specific. So you may be, having an innovation here, probably not patent protected, or maybe even patent protected in India. You sit very happy, okay, I have a patent here, I have it here, I am doing my business, but there may be somebody who manufactures that product in some other country. And you would not be able to stop them because you do not have your IPR protected in that country. So when you protect your IP, you need to go for an all-round protection throughout various geographies, because IPRs are territory specific, be it trademark or patent. Copyright is another matter. If you are you protect in one of the countries under the Berne Convention, but other than that, regarding trademark and patent, you need to protect your IPRs specifically in the various geographies. So you need to ask yourself, what is the end goal of my company? Does the IPR that I have created achieve that end goal? You need to assess your business's registered and unregistered assets. You need to grow and curate your IP to achieve that particular end goal, if my end goal is that I want to reach this particular crore target within the next 5 years, is my brand that I have developed, as Madam Sindhuja just said, is it so, unique that people would immediately relate my product to my brand? Will it help me achieve that particular goal that I have set for the next 10 years? That you need to look at. Or if you have an invention, you have, a kitty of 7 inventions, what exactly would form the foundation for the development of my business and for me to achieve that particular 10-year goal? Which particular invention should I file a patent for? Okay, I'm filing a patent for this invention. Should I file one patent or a couple of patents? Should I file only in India? Should I file in other geographies? All these has to be strategized upon when looking at what IP you need to protect, how you need to protect, and where you need to protect it. And how can I leverage my IP if my end goal changes? Plan A is always there, but you should be prepared with a plan B or a plan C. If at all I am not able to attain my target, is my brand and my innovation amply protected by IP so that I can monetize it in future by probably assigning it to somebody or licensing it to somebody? All these you will have to keep in mind when selecting a good brand, when looking at patenting for your innovation, when looking at filing patents and trademarks for your brands and innovations. All of you are familiar with Doctor Strange in Marvels. The thing that he does when he faces any threat or danger is he immediately creates the mandala to shield himself and others who may be relying on him. That is what you need to do. Filing your IP is creating the mandala for your brand or your innovation, without which you would be lost as the years go by. The initial years may show a roaring profit through your use of that brand or innovation, but as the years go by, you will not be able to sustain what your business has shown in the initial days. And what can be protected? An invention as patent or utility models, a creative work as a copyright or design, brand name or logo as a trademark and copyright, confidential information as trade secrets, designs, and plant varieties. When do you start protecting your idea? As our speakers from the IP office have emphasized time and again, file at the earliest. The first to file wins. First to file both whatever intellectual property there is. So the moment you file, you are the owner of that particular intellectual property. So before filing, you need to check the landscape, which is why you come to us for trademark searches, patent searches. Let me know what else is there, what my competitors have filed, what companies who are not my competitors have filed. Let us know so that we can strategize. That's what you come and tell us. Which IP rights do you need? Do you need only patent or patent and trademark or patent and design? That we let you know on. Do you need investors? If so, you need to value your IP. And do you need partners? Sometimes the journey can be undertaken with partners, if not solely. That also you need to decide on. So you need to search IP databases, and if not, the IPR owner can claim damages from you. Also, you need to seek legal advice, because believe it or not, it will pay off. Most of the times, people think about the costs in spending all this, in filing the IPO, evil fees to file a patent. It all finally pays off in the end. The importance of patent mining, FTO search and infringement analysis. See, it indicates whether you can actually get the protection for your invention. If you find that there are no other similar patents, go ahead. It flags other rights that may prevent you from offering your product. Okay, there is somebody sitting with a patent in the US. Fine, I will not commercialize my invention in the US. Let me commercialize my invention in India. It reveals opportunities to monetize your IP through licensing. You may come across somebody else who needs your IP rather than much more than you. And steers early R&D decisions, gives a snapshot of the technology landscape. Why protect brands? It boosts your brand image and reputation, generates income for you, gives an indication of the value of your company for potential partners and investors. Always think 10 years ahead, 20 years ahead. See, your brands, finally, you may enter into a JV, you may enter into an M&A, you may go for acquiring another company might look for acquiring you. At that point of time, all these things that you have done will serve you well. there is this, tradition that all the expeditions that go to Arctic and the Antarctic, they leave all these canned food buried in the ice. It's not for them to use. It's for people coming on future expeditions to use. So they leave all those buried in the snow at specific, points that the coming team also knows, so that anybody in an emergency can use those. These are your canned food for anything in an icy future. All this protection that you will be going for. And there are different ways to monetize your assets. So you can use them, or you can license them, you can sell them, you can go for a technology transfer, you can go for a JV, an M&A, and you can go for pledging your IP in order to secure corporate or venture debt.